The State of Crypto is presented by Tron, connecting the world to the power of cryptocurrency.
The SEC is taking aim at Gemini and Genesis Global Capital. The government agency is alleging the crypto firms sold unregistered securities to retail investors through the Gemini Earn crypto asset lending program. Genesis and CoinDesk are owned by parent company Digital Currency Group. All right, joining us now to discuss is Howard Fischer, Moses Singer partner and former senior trial counsel at the Securities and Exchange Commission. Howard, great to have you on the show. And I guess my first question is, why didn't so they didn't register the program, Gemini Earn, Gemini, Genesis. Right. They did not register the program with the SEC, but why is the SEC going after them now? I mean, after the fact, their mandate is to protect consumers, but they're a little late on that.
Yeah, I mean, this is a criticism that has been levied against the SEC a lot, and not just in the crypto space, is that they come in when everything falls apart, as opposed to at an earlier stage when perhaps they could remedy the issues before they become a disaster. So, I mean, I think what you're seeing here is in part the SEC reacting to the news cycle, and, you know, the SEC, frankly, just doesn't have the staffing and the bandwidth to regulate the entire industry and to protect everyone. So often their actions are after the fact, once a disaster has happened, once people have started losing money, or after a scheme collapses, they come in and they prosecute the problem. But a lot of this is due to the fact that they can't be everywhere, and it is a fair criticism to ask, well, why wasn't this registered before? And we've seen this actually. We've seen the SEC bringing actions against other companies before they've started offering a program, arguing that the instruments at issue were securities. So I think it is a fair question to ask, why didn't they do that in this case, and why are they only going after it once it's been a disaster?
It sounds like almost echoes of Sam Bankman-Fried in that you go on Twitter and you try to explain your case, and it's almost like somebody at the SEC is taking down notes and like, oh, we might have a case. Is that kind of where you're going with? And also, you want to say something?
I was going to say I don't think anything like Sam Bankman-Fried, and I say that having just subscribed to his Substack. I don't think I've ever seen a major case in crypto or otherwise where someone who is obviously facing potential charges decides that the best thing to do is to go public. So that's a somewhat unusual circumstance and something that you tend not to see. Most people take their lawyer's advice about their right to be silent. Apparently, Bankman-Fried doesn't understand that that's also a good idea. But I think that you are right. The SEC does monitor the news. You do look to what people are saying, and it's when there's this standard pattern in a lot of cases where things go pear-shaped, and after that, people who are involved with the companies issue some exculpatory statements where they say, oh, it was a problem, we're really working through it, but don't worry, everything's going to be fine. And that does get the SEC's ire, because it's clear, at least in this case and in many cases, that things might not be fine. And a lot of people who work internally at companies don't want to say that, and that's the kind of thing that might bring a prosecution action.
So Christine alluded to the SEC's previous actions or some of the things that happen against, for instance, telling Coinbase they can't do this kind of a program similar to Gemini and Genesis. And of course, they came after all these other lenders. Is this case an example, or are they trying to set a precedence in this case? Like, look, if we win this case, we're going to go after all crypto lenders, centralized crypto lenders. And does this have any implication for DeFi, or is that a different concept enough that they can't really do anything there?
Yeah, I mean, it's always difficult to generalize from one case to a general trend. And in this case is somewhat interesting. I mean, look, one of the things that's important to note is that the SEC is not, in this case, saying that the coins and the tokens at issue were securities. They're saying that the lending program, which is really a standard note offering, is a security. So they're attacking that rather than the securities itself, rather than the tokens or the coins involved. I do think that the SEC has been trying to stake out its ground as the regulator for crypto. As you know, there are lots of competing bills in the Congress right now, which will establish a crypto regulator. Some call for the CFTC, some call for the SEC, others call for the creation of a self-regulatory organization. And I think that the SEC has been very, very vocal in saying that when it comes to the trading of these issues, when it comes to exchanges, and when it comes to these kinds of note programs, they want to be the regulators. I think this is in part the SEC staking out its ground in this area. And I think there is a significant chance that we may see them try to expand this if it's successful.
Well, again, the SEC told Coinbase that they were not allowed to have their lend product, their lend program. And Coinbase backed off. And in this case, they let Genesis and Gemini run their own earn program without anything. So it is very confusing and gray out there. Meanwhile, Tyler Winklevoss tweeting that it's disappointing that the SEC chose to file an action today as Gemini and other creditors are working hard together to recover funds. This action does nothing to further our efforts and help earn users get their assets back. Their behavior is totally counterproductive. He went on to tweet, as a matter of background, the EARN program was regulated by the NYDFS, Department of Financial Services, and we've been in discussions with the SEC about the EARN program for more than 17 months. They never raised the prospect of any enforcement action until after Genesis paused withdrawals on November 16th. And also note that in a news release, the SEC states in part investigations into other securities law violations and other entities and persons relating to the alleged misconduct are ongoing, and about 340,000 earned customers are out a pocket of roughly $900 million. And so, I mean, with this enforcement action, does it help protect consumers at all in getting their money back and making them whole, or does it make it worse?
Yeah, it's funny. This is what we used to call at the agency the Scooby-Doo defense, which is, if you've seen the Scooby-Doo show, it's, I would have gotten away with it if not for you pesky kids. And a lot of times when there is an enforcement action, the people at the company say, we were working on this, we were going to make everything okay. Now that you've brought a case, everything is up in the air, people are fleeing, and it's completely unhelpful. So this is very common that people who are the subject of an enforcement action argue that they were working it out by themselves. Apparently the SEC disagreed.
Bro. This is, again.
But will this end up, if there's this enforcement action, will it just end up, in a big fine, a settlement, but consumers are no closer to actually being whole?
That may not be the case, because depending upon how much money is there, if the notes at issue were unregistered securities, then consumers would have the right to rescission. And I'm sure, as you know, there's already been a class action filed about this, which alleges that the notes are securities and which argues that they should be allowed what are known as rescissory damages, which is, I can take back the money that I invested. So, a lot of this depends on how much is there, frankly. And if a lot of the collateral for this is, for example, FTT, FTX's proprietary coin, it's not likely that there's going to be much of a recovery. So much depends on how much is there. But I think the SEC, if they believe that this is an unregistered security and that it shouldn't have happened, they're going to try to unwind the clock and make sure, to the extent possible, that customers are made whole. But obviously that is limited by the assets that are available.
And how long does a thing like this usually take? I mean, obviously every case is different, but something, if you had to ballpark it, how many months or years does it take?
Months? No, it's not definitely not months. And it's not like Law and Order where everything wraps up in one 60-minute episode. These cases can take years, and if depending on how this is contested, if they make a motion to dismiss, arguing that these are not securities, that could drag it out for 6 months or more just dealing with that motion. Discovery can take years. If this is a highly fought and contentious case, this could take 3 to 4 years.
Wow.
Yeah,
right.
it's one of the complaints that people have about the judicial process.